Well, good morning, good afternoon, everybody. Welcome to the CELS lunchtime seminar. I'm really very pleased to welcome Dr. Or Brook from the University of Leeds. She is the Deputy Director of the Centre for Business Law and Practice and one of the rising stars in competition law academia. She's here today to speak about one of the most topical debates, which is the narrowness or breadth of the things that you can consider in a competition law authority. She's agreed to speak formally for around 20-25 minutes, and then is happy to take questions. Or over to you.
Thank you. We are also quite a small group. So if you have any questions in the middle or anything you find more interesting, also about the methodology or in general, feel free to stop me and we can see how the lecture goes. So thank you very much for the invitation. It's really lovely to be here. Today I'm going to present my book, which should be out any day now. And there are some discount codes here if you're interested afterwards. Okay, what I was hoping today is just to give a bit of a context of the question of the role of non-competition interest in EU competition law, talk a bit about the project and especially the methodology, which is quite different than regular legal analysis, then present some of the findings and some of the recommendations that come out of the book. Okay, so just a bit of the context of this legal question. So, a good example of the question of how to balance competition and non-competition interest is a Dutch coal power plant case of 2013. In 2013, all power plant operators in the Netherlands came together and they decided to accelerate the closing down of their coal power plants and to move to more sustainable, greener ways of energy production. This type of arrangement was broadly supported in the Netherlands. So local government was part of the arrangement, NGOs, all of the industry. However, it was also clearly anti-competitive because it was clear that as a result of the disruption of the market forces, the prices of energy in the Netherlands will go up, at least in the medium to short term. And therefore, the Dutch Competition Authority decided to block this transaction, noting that it's illegal, it's a cartel arrangement under both EU and Dutch competition law. So this case, like many other, raised the question of how public policy considerations or non-competition interests, which are almost the same thing, can be taken into account. This is definitely not a new question. So Adam Smith, the founder of modern economics and such also of modern competition law, had already addressed this issue, labeling the consideration of non-competition interest as affectation, as a false claim, and saying that not a lot of words need to be employed in order to rule this option out. Now, although Smith's work was fundamentally inspiring competition law and EU competition law, he got it quite wrong when it comes to this question, because the debate on the role of non-competition interest is one of the fundamental issues that could come in again and again every few years. In fact, if we look at the EU treaties themselves, they seem to leave some room for the considerations of non-competition interest. Therefore, while Article 101.1 prohibits essentially any type of anti-competitive agreement, Article 101.3 set the exemption if you can fulfill those 4 conditions. However, although Article 101.3 suggests that there is some room for some non-competition interest, its vague wording makes it very difficult to understand what competition interests could be relevant and how to take them into account. So if we take, for example, again, the example of the Dutch coal power plant case, it's unclear if sustainability or reduction in pollution can be taken into account. And that becomes even more complicated if you go for even less tangible interests like animal welfare, employment, culture, or the EU industrial policy. Therefore, this question mostly was left to the interpretation of the competition authorities and the courts throughout the years. In the past, from the beginning of the enforcement of EU competition law in the 60s and up until quite recently, the Commission and European courts interpreted the provision of Article 101.3 quite broadly as leaving room for ample types of considerations of non-competition interests. In fact, all of the examples that I showed before, so sustainability, employment, culture, industrial policy, were all found as relevant interests that can and should be taken into account under Article 101(3). In particular, the Commission has interpreted Article 101(3) not only as being about competition law and exceptions to the competition rules, but also as a tool to shape the European markets. And that was especially true from the 60s to the 70s, 80s, and 90s, as the European integration project has emerged, as markets started to open to competition through the process of liberalization, and the internal market became more and more integrated. Now, the possibility to take into account non-competition interests in Article 101(3) is not only a substantive question, but was also supported by the enforcement regime. So up until 2004, under the enforcement regime of Regulation 17, all anti-competitive agreements were notified to the Commission before they could have been implemented. The Commission could decide whether to approve or reject them, or more often, the Commission can engage in negotiation with the undertakings to try to change the conditions. So this allowed the Commission to examine the role of non-competition interest in agreements even before the agreements were implemented, and to try to reach a compromise with the undertakings. The debate over the role of non-competition interest was revived around the turn of the millennium as part of the reform or the modernization of EU competition law. Now, each one of the three pillars of the modernization has actually affected the possibility or room for considerations of non-competition interest under Article 101(3). Under the first pillar of modernization, the substantive one or the more economic approach, EU competition law has shifted from a formalistic analysis to a more economic approach, a more effect-based approach, which focuses on consumer welfare. As part of this shift, the Commission has emphasized that Article 101(3) is intended to provide a legal framework for the economic assessment of restrictive practices, and not to allow the application of the competition rules to be set aside because of political considerations that were interpreted also as non-competition interests. But this change in the Commission position is also reflected to a more political or more practical concern, which involves the decentralization of the enforcement. So from 2004, Article 101(3) is not being only applied by the Commission, but also has a direct effect, meaning that also the national competition authorities can apply the article. The Commission wanted to make sure that national competition authorities, that not all of them share the same competition culture, especially back in 2004, will interpret the article as being about economics and consumer welfare, and will not allow for protectionist measures. Finally, the third pillar of modernization, the procedural one, is the shift from a prior notification system to self-assessment. That means that undertakings now need to self-assess their conduct and to decide whether or not it can be exempted under Article 101(3). And the Commission only examines, and the national competition authorities only examine compatibility with Article 101(3) ex post. Because Article 101(3) finally had a direct effect, that means that it needs to be more clear and unequivocal, and there's less room for balancing because undertakings might get it wrong. Now, the combined effect of all those three pillars of modernization led many scholars, and that's probably a quite strong consensus, to conclude that the modernization of EU competition law has reduced the role of non-competition interest, if not completely eliminated that, especially when it comes to the enforcement of Article 101. In this book, I tried to produce empirical evidence to question this common view and actually say that the modernization of competition law resulted in an increase in the role of non-competition interests. So how do I come to this conclusion? Before I will present the findings, I'll just take a bit of time to explain about the project. So going back to the coal power plant case, as you can imagine, blocking this type of transaction in the Netherlands has created a huge debate, a huge public outrage, which was perhaps bad politically. It was great for me personally, because it led the University of Amsterdam to finance and open a PhD position to examine the role of non-competition interest in EU competition law. So they opened the tender for a PhD position specifically for this topic. And you can imagine that because this topic was already debated and researched for such a long time, it was quite difficult to come up with a new perspective or a new way to examine this topic, especially since many people before me and very big names in the field too did already an excellent job to examine this question from a constitutional perspective, from a historical perspective, and so on. So what I did in my PhD project was to take a different approach, which is a more empirical one. I had three main research questions. One was empirical doctrinal, so to try to identify the rationale, method, and limits for the balancing of competition and non-competition interest and how they changed over the year. The second phase was assessment, so how did this process of evolution actually affected the objectives of the enforcement as they defined under Regulation 1/2003. And a normative element of trying to think what role should non-competition interests have and how they should be taken into account. In order to examine those three questions, I applied systematic content analysis, which is also known as coding, of all Article 101 TFEU public enforcement proceedings, which are defined very broad, not only as formal decisions, but also informal decision, press releases, mentioning in annual reports, so every information that we have about a case. Looking at appeal at those decisions and preliminary ruling applying Article 101 by the European Commission and EU courts from the 50s to 2017, which is a cutoff date, and how Article 101 and the national equivalent provisions were applied by 5 member states. The UK was one of them back then, but also France, Netherlands, Hungary, and Germany, I missed one. Now you can imagine that this was a pretty big endeavor. So we are talking about a database of over 3,100 cases that had to be coded. And based on systematic content analysis, this is the output of the coding, which took a year and a half of my PhD full-time just to code. So the output of the coding is just an Excel sheet where each row represents a case, so a decision, and every column represents a variable. A variable would be one element of the case. The coding book had defined 41 different variables. Some just relate to case identification, so which court, date, and so on, the name of the parties. Some variables were about the undertakings. Some were about the non-competition interest invoked in the case, so what type of non-competition interest, but also what its normative value is enshrined in the EU treaties, is it a national interest? I looked at balancing tools under Article 101.1. So here you can think of things like the de minimis doctrine or the Wooters, ancillary restraints, and so on. The application of Article 101.3, and then other questions like the interaction between those balancing tools and free movement rights, Article 102, and also information about the outcome of the case. If you're interested, you have the coding book here. Okay, for each one of the variable, and you can also see that the coding book has defined a pre-existing list of value labels. That means how this specific variable can be interpreted. For example, if the case examined consumer under Article 101.3, how it was defined. Was it as a direct consumer or society as a whole? Now, the use of systematic content analysis in law in general allows us to code discretion. So it's a way of a bottom-up approach to approach legal questions. So instead of thinking how the law should apply, you're looking at how the law is actually being applied. And that's allowed to code visible cases or explicit substantive balancing tools like Article 101 and 103. As I mentioned, you can look at the type of non-competition interest, the balancing method, what kind of proportionality test was used, is it a legal or economic one, the intensity of control in terms of evidence, the frequency of use of those cases, and so on. However, and I think perhaps more interestingly, systematic content analysis also allows us to look at the dark matter of the enforcement. That means ways to take non-competition interest into account by not enforcing the law. More specifically, because it was a change in the enforcement regime in 2004, if we compare the white core, so the cases that were decided on the merits in terms of balancing questions after 2004, and compare it to cases that were examined before modernization. So when the commission had to examine all of the agreements that was notified to it, we can try to see which cases the commission decided not to bring forward. And as I will show you later, I think that this is where most of the interesting debate actually lies. So in terms of the state of the art of the project and hopefully of the book, so first of all, it's taking an empirical approach to examine an old question and looking at the dark matter of the enforcement. The book also examines new balancing tools. So most of the focus so far was on Article 101 free balancing, a bit on Article 101.1. The book also allows to examine balancing through block exemption regulations, unique national exceptions that are, so it's rules that adopted by national competition authorities or by member states that somehow affect the application of Article 101, balancing by way of remedies, and balancing by enforcement discretion, so choices of priority setting. Finally, the book allows a new perspective to the role of non-competition interest because it sheds light on national enforcement. So most work previously mostly focused on EU competition law enforced by the Commission and EU courts, although since 2004, around 90% of cases having effect on trade between member states are actually examined by national competition authorities. Any questions about the methodology so far? Okay, so we can go to the findings. So just to remind you, what I'm trying to prove now is that the modernization of EU competition law has actually increased the role of non-competition interest in the enforcement. And although the book is out now, if you are critical or not convinced, please let me know and I will try to defend it better. So the first graph, which I think is interesting, is to examine the application of Article 101 free throughout the years. So what you can see here in the yellow bars are the cases where exemptions under Article 101 free were granted. The upper black line represent all of Article 101 TFEU proceedings over the years. And the dotted lines are all cases where Article 101 free was invoked, was argued by the parties. So from a first look, you can see that Article 101 free was never successfully invoked after 2004. And this is actually, so as far as I know, this is the first time that it's being recorded empirically, but a lot of people knew that. Article 101 free is a dead letter, is not really applicable since 2004. And this actually seems to support the opposite of what I'm trying to say. However, because we applied systematic content analysis, this graph also shows us a second trend, which I think is actually more interesting, which relates to the invocation rate of Article 101 free. So you can see that up until 2004, Article 101 free was invoked in 57% of the cases. And this figure is similar, doesn't matter how you cut the years. So even if you just take 5 or 10 years before that, while after 2004, starting exactly after Regulation 1/2003 entered into force, the invocation rate of Article 101 free dropped to 25% of the cases. Now, this is really an odd finding because it shows that while the Commission decided to move to a more economic approach, and that started already in 1999, just in 2004, suddenly in one day, lawyers have decided to stop to try to invoke Article 101 free in cases in front of the Commission. And we also know that the Commission guidelines are not binding. So why would lawyers decide to stop even trying to invoke Article 101 free? In the book, I say that this could be explained if we look at the nature or type of agreements that the Commission has decided to pursue following modernization. So as I said before, because of the switch from notification system to self-assessment, the Commission can decide to select which cases to take and which to disregard. We can see that following, oh, sorry, you're not seeing the right one. You can see that following modernization, the Commission have mostly taken cases that started by leniency application, often together with settlements, which are cases that by definition refer to cartels, normally secret cartels. And those are cases which are unlikely to involve non-competition interests, right? So we don't really think that undertakings will come together secretly in smoke-filled rooms and try to save the world. it's more likely that there will be agreements which are purely anti-competitive and non-competition interests are not even relevant. We can see that Article 1013 was discussed in cases involving commitments, although because it's commitments, we don't know if Article 1013 would have applied before or after receiving the commitments. And we can see that Article 1013 is incredibly prominent in other types of proceedings, which in a way resemble more the proceeding the Commission examined before the switch to a self-assessment regime. Now, this finding is true with respect to Article 1013 balancing tools, but it's also true when you look at balancing via Article 101 balancing tool and the block exemption regulations. The same is true if you focus down, if you look in at balancing that happens at a national level. So this graph shows you the invocation and acceptance rate of Article 1013 by the Commission, UK, Hungary, France, Netherlands, and Germany. And you can see that in many cases, non-competition interests, which are not related to efficiencies, so public policy considerations, things like sustainability or employment, which are represented here in red, were not even examined in many of the member states. So the Commission have hardly examined those type of cases, and that's true also in the UK. In Hungary and France and the Netherlands, those non-competition interests were actually examined, were seen as relevant, even if in the end, sometimes they did not justify an exemption. And in Germany, and that's not really clear from this graph, but from a closer analysis, Article 1013 was actually interpreted as a way to exempt agreement that enjoy support by by the government. So if the government endorses an anti-competitive agreement, it will be exempted under Article 1013. So the book shows that Article 1013 was interpreted in various different ways in the national level. And we can also see that in the end, while some Article 1013 cases were examined and sometimes granted, in most cases, those questions were not actually examined in front of National Competition Authority, similar to the Commission. The final part of the book examines balancing of competition and non-competition interests via enforcement discretion. So this is the implicit procedural balancing tools or the dark matter of enforcement. Here you can see different elements that the book goes into. So to examine balancing via the detection strategy, so how we even identify non-competition interests. And I show that by relying on leniency and settlements and reactive policies, actually agreements that are likely to raise genuine non-competition interests do not even appear in front of the competition authorities. I look at target discretion, instrument discretion, and outcome discretion, which I will not have time to discuss all. But I want to give you one example, which is, for example, balancing by commitments. How am I doing with time? Can I have, yeah, okay. So this graph, for example, shows the type of sectors where commitments were accepted in the different national competition authorities. And even if you look, just have a quick look just at the colors, you can see that there are four main sectors. The bluish, which are liberalized and regulated markets, green, which are technology markets, and red, which are financial services. And only the gray areas are other types of sectors. So you can see that those others were prominent in Hungary, but that's it. The rest of the countries really focus on those three sectors. And you can see that those three sectors and those types of questions are exactly the type of agreement that the Commission examined prior modernization under Article 1013 and granted exemption in many of those cases. So what I say in this book, that actually it's seen that the Commission has substituted Article 1013 function prior to the modernization by commitments, while other types of cases are not being even brought in front of the Commission. So if the Commission needs to balance competition and non-competition interests, it's more likely to disregard the case altogether or to resolve the case by commitments rather than applying Article 1013 or Article 1011 balancing tools. This is also shown by this graph, which summarizes the book. So if you look at the black bars, especially up until 2004, there are cases where the Commission actually applied the explicit substantive balancing tools. And you can see that since 2004, with the exceptions of very few cases, the Commission doesn't apply those substantive balancing tools, which I say actually hints that the Commission decided to shift to balancing by using the implicit procedural balancing tools. So why do we care? Or what are the impacts of this shift? And I'm going back to the free research questions and trying to summarize the findings here. In the last chapter of the book, I show that there are three main transitions in the way that non-competition interests have been taken into account. The first one, which I already mentioned, is a shift in the balancing tool. So up until modernization, the Commission, when it was faced with the question of how to balance competition and non-competition interests, the Commission has examined this case head on, actually discussed the balancing, actually discussed what non-competition interests are relevant using the explicit substantive balancing tools. Since modernization, all of those questions are only examined through procedural implicit balancing tools. That means that there is no actual public or legal debate. Those questions are then not subject to public debate or judicial review. And that means, in a way, that even if in the past Article 101(3) was interpreted very broadly, at least we had some legal structure to guide the enforcement. Nowadays, because the Commission can decide, and a national competition authority can decide which cases to take and which to disregard, it's likely that they will disregard cases where public policy considerations are raised, even if the conditions of Article 101(3) cannot justify this case. So in a way, it actually increased the role of non-competition interests. The second shift that is shown by the empirical results is a change of the locus of the balancing tools. That means that instead of having balancing tools that are being interpreted and applied in the EU level, they're being interpreted and applied by the member states. Now we can say, okay, this is a natural result of modernization, but actually we can see that here there are two trends that are happening together, and they're not very visible in the EU level. So first of all, we have national competition authorities that interpret, and national courts that interpret the EU rules. And we can see that sometimes they use very different interpretations. And second, we can see a host of national balancing tools, so national rules, like national block exemption regulations, national exceptions that allow to limit Article 101(1), and which are not even clearly compatible with EU law. And again, no debate or hardly any debate on those types of cases. Finally, we can also see a shift in the role of EU courts. So prior modernization, the EU courts were very involved in scrutinizing and developing new tools to balance between competition and non-competition interests. After modernization, we can see that the courts became incredibly passive. Even if the courts once in a while examine a case of balancing, use very vague and weird wording that does not really give us an answer on the role of non-competition interest, which allowed the Commission to continue and advocate the consumer welfare focused approach. Each one of those transitions, in my opinion, actually undermine the objectives of Regulation 1/2003. So as a result of the shift to the implicit procedural balancing tool, the balancing or the role of non-competition interests is less effective. Again, because there's no structure or no limits on what type of non-competition interest can be taken into account. The result is also less uniformity, which again, is also a result of decentralization, but it was reinforced because of the national interpretation and the national balancing rules, and less legal certainty because the court leave the question of the role of non-competition interests incredibly vague. In terms of recommendation, I think that the empirical findings prove that non-competition interests have and will always have play a role in the enforcement of Article 101. So even if we want to leave competition law only about consumer welfare, those public policy considerations will come to haunt us again and again and again. They might change a bit their nature. So in the past, I think employment and stability of the market was a big thing. Now it seems that sustainability is a huge thing. We saw it in the coronavirus. So even the Commission and the UK Competition Authority, which are very careful in limiting the competition rules, all agreed that some relaxation of the competition rules should take place during the COVID pandemic. And therefore, I think that the debate should shift, should start from the premise that non-competition interest will play a role and focus on how they should play a role. What I suggest is that national competition authorities will try to have a more diverse portfolio of cases. That means that while leniency in settlements are, and the fight against hardcore cartels is of course an important priority, it's still important that they will take cases which are maybe softer, involve also non-competition interest, and make their position clear. This means also that competition authorities should go back to the explicit substantive balancing tools. That means that if they are faced with a legal question on the role of non-competition interest, they should be brave, knowing that they will face public and judicial review and actually apply Article 101(3). So to explain that, what are the type of benefits that can be taken into account, what is fair share, and so on. That means it will take a clear approach, subject to public and judicial review, and which also allow to the respect of Regulation 1/2003. As a last point, I think that if you are looking at the Commission's new draft guidelines for horizontal practices and vertical practices, it does not seem that the Commission is going in this direction. So the vertical guidelines, for example, have returned back to the situation before 2010 and have a whole chapter about sustainability agreements. But once again, the guidelines don't tell us much. So they introduce, I've been doing it for a few years and I have no idea on how to apply the guidelines to a specific agreement. It could really be interpreted both ways. The guideline introduced something new, which is a soft safe haven. Doesn't explain what it means, but I assume that it means that there's a presumption that the agreement is anti-competitive, meaning that those agreements, again, go back to enforcement discretion and probably will not be enforced. Again, we would not know what type of agreements are seen as acceptable by the Commission. So I'll pause here. I mean, there's many more findings. There are around 50 graphs in the book, which I hope will be of interest not only to the question of non-competition interest, but also just about the success of the application of Regulation 1/2003 and enforcement of competition law following modernization. Thank you very much.